Swayam Prabha. Digital India. Educated India.
I am Dr. Saurabh Rana, and I, along with Professor Dr. Vageshwari Deshwal from Faculty of Law, University of Delhi, would be discussing procedural criminal law contained in Bharatiya Nagrik Suraksha Sanhita 2023. Today, in this session, we shall deal with security for peace and good behavior. This is chapter 9 in Bharatiya Nagrik Suraksha Sanhita, and there are two types of bonds that are contemplated here. One bond is to keep the peace, and the other bond is to keep good behavior. Now, before we move further, let us see how the conditions of two bonds differ. So, if we see the idea of keeping peace, it is associated with those people who are of violent nature or those who are prone to commit violence. And the bond to keep peace is contemplated under section 125 and under section 126 BNSS, whereas good behavior is supposed to not to commit any offense which may be punished with imprisonment, and bond for showing good behavior is contemplated in section 127, 128 and 129 BNSS. So, as I said, keeping peace is contemplating those people who would be prone to violence. So, as I said, section 125 and 126, they deal with the authorities asking them to furnish bonds that for a certain period of time they would not be showing their violent side, as in they would keep peace in the society, they would not commit breach of peace. So, if we see section 125 and the offences with which it deals, we find that it deals with chapter 11 BNS. Chapter 11 is for offences which are against public tranquility, unlawful assembly, rioting, affray, etc. Then it says offences which consists of assault or criminal force or mischief. Then it deals with offence of criminal intimidation. Then it deals with those who intend to commit breach of peace, etc. So, here we see that the people who are likely to cause breach of peace, who are likely to show or to commit violence in the society, they are asked to furnish a bond by judicial magistrate or by executive magistrate, as the case may be, under section 125, 126 respectively. And on the other hand, if we see section 139, then we will come to know that bond for good behavior is contemplated in a case where the person through a bond assures the authorities that he would not commit of any offence which is punishable by imprisonment under BNS. So, section 139 says that the bond to be executed by any such person shall bind him to keep the peace or to be of good behavior, and in the later case as in bond for good behavior, the commission or attempt to commit or the abatement of any offence punishable with imprisonment would be considered as a breach of that bond. So, if after furnishing this bond, the person again commits an offence punishable with imprisonment under BNSS, then it would be considered as a breach of that bond. Now, this is the idea about keeping peace, bond to keep peace and bond to show good behavior. The idea is that here the person is asked not to commit breach of peace, as in not to commit violent act in the society. And here, bond to show good behavior, he is supposed not to commit any offence punishable with imprisonment. Illustrate the difference between the two situations. So, if somebody commits theft, he may be asked to furnish a bond here. Not that he would be asked to furnish a bond to keep peace, because theft is something which, as an ingredient of offence, it does not contain breach of peace, assault, intimidation, rioting, etc. So, if a person is, say for example, he is habitual in committing theft, or if he is convicted of theft, then he may be asked to furnish a bond for keeping good behavior, but may not be asked to furnish a bond for keeping peace. Good behavior bonds are there in section 127, 128 and 129. On the other hand, if somebody does rioting or somebody assaults somebody or intimidates and is habitual in these things, so there is every apprehension that he would in future also would do that. In that case, he may be asked to furnish this bond to keep peace. So, that is the background of these two types of bonds, bond to keep peace and bond to show good behavior. And they have different sections, and now let us see what authority may ask them to furnish what kind of bond and in what situations. Now, let us see section 125. This is security, that means in the form of bonds that the person would be asked to furnish bonds, personal and sureties. Now, security for keeping peace. Now, this is the further condition on conviction. So, as we discussed, section 125, 126 are contemplating bond for keeping peace, 127 to 129 bond for good behavior. Now, this is the first section here, and it says, and the condition is that somebody would be asked for furnishing bonds, personal bond, sureties on conviction of these offences which are mentioned in section 125. And when I say conviction, it means essentially the judicial courts, because conviction, as we have already discussed in some other session, conviction is a result of trial, and trial would be held by judicial magistrate, court of session, high court, in extraordinary circumstances. Trial is a judicial function, that is after the commission of, see, executive magistrate is a criminal court, but under section 6, but then it has no business to hold trial. They have the law and order maintaining functions. So, they do not hold trials. Holding a trial is only after commission of offence. So, somebody commits offence and then the judicial courts hold trial and convict or acquit somebody. So, conviction is an essentially judicial court's idea, and hence we see this. I am saying because under section 126, 127 to 129, executive magistrate courts concerned. Under section 125, only judicial courts are concerned, only judicial courts. Now, because as I said, only a judicial court can convict. So, it says when a court of session or court of magistrate of first class convicts a person of any of the offences specified in section 2 or of abetting such offences, is of opinion that it is necessary to take security from such person for keeping the peace in the society, the court may, at the time of passing sentence on such person. Sentence is also something intricately linked to judicial courts. Sentence and conviction, they are both linked to the idea of a judicial court. Order him to execute a bond or bail bond for keeping peace for such period not exceeding 3 years as it thinks fit. And if we read clause 2 here, as it says, convicts a person of any of the offences mentioned in subsection 2, this is subsection 2, and it says any offence punishable under chapter 11. If we look at chapter 11, it deals with unlawful assembly, rioting, etc. So, the offences are of violent nature. B, it says assault, criminal force, mischief, again violent nature. Any other offence caused, intended or known to be likely to cause breach of peace, again violence. If so, these are the offences. So, they all are of violent nature, and if somebody is convicted of these offences, then at the time of passing sentence on such person, the judicial court, as in court of session or judicial magistrate first class, may ask such person to furnish bonds, personal surety for such period of time that they would be keeping peace in the society not exceeding 3 years. Now, subsection 3 says, if the conviction is set aside on appeal or otherwise, the bond so executed shall become void. Of course, if conviction is set aside, then the bond also would become futile in that case. They would become void, as subsection 3 says. Then it says, an order under this section may also be made by an appellate court or by a revisional court. So, if a revisional or appellate court, so if the trial court does not make such order, it is that an appellate court or a revisional court may pass such order. Now, let us look at the next section. Here also, we are contemplating peace, but the difference here is that it does not talk about convictions, sentences, and so they are not necessarily related to judicial courts. In fact, when we read section 126, it mentions executive magistrate. only. When an executive magistrate, and you see here executive magistrate, it says when an executive magistrate receives information again, but the idea when it is about peace, the idea would be the offences related to violent activities. So, when we read this provision, we would also feel that section 126 is also around the violent activities which a person may commit. It says when an executive magistrate receives information that any person is likely to commit a breach of peace or disturb the public tranquility or do any wrongful act that may probably cause breach of peace or disturb the public tranquility, and is of opinion that there is sufficient ground for proceeding. So, that means he has to record, he has to show and record the grounds that he thought that why such person should not be ordered to execute a bond or bail bond for keeping the peace for such period again, but here the time limit has been further restrained, it is not exceeding 1 year as the magistrate thinks fit. Now, subclause 2 further says that proceedings under this section may be taken before any executive magistrate when either the place where the breach of peace is apprehended is within his local jurisdiction, or where there is within such jurisdiction a person who is likely to commit a breach of peace or disturb the public tranquility. So, some link must be there, either the place where the breach of peace may be committed, though the persons may be living beyond his territorial jurisdiction, outside his territorial jurisdiction. So, either the place should be there in his territorial jurisdiction, persons may be living outside, or the persons may be living in his jurisdiction, place may be outside, place where breach of peace that they would commit falls outside his territorial jurisdiction. In both cases, he can exercise jurisdiction under section 126 and ask such person to furnish a bond not exceeding 1 year to keep peace in the society for, of course, for a time not exceeding 1 year. Now, let us see some other observations in this context. It has been observed that the proceedings under section 125 and 126, this by judicial courts, this by executive courts, executive magistrate court, are founded on the same policy, and the idea is that somebody's past conduct, if leads to an apprehension for the future that he is likely to act to the detriment of public peace and tranquility, that he may be asked to furnish such bonds as under section 125, 126. This has been observed by the Supreme Court in Madhu Limye versus SDM AIR 1971, Supreme Court 2486, AIR 1971, Supreme Court 2486. It has also been observed that the proceedings here are preventive in nature and they are not punitive. So, if somebody has already committed a crime, then he would be convicted by a judicial court, and for the offence which has already been committed, the bonds are meaningless. The bonds would be furnished only if the court feels, judicial court while convicting feels that he would do the same activity in future also. So, the idea is that these bonds are preventive in nature, not to punish him, punishment would have already been granted by the judicial court. And at the time of passing sentence, the judicial court may ask such person to furnish such bond, that is section 125. And if it is an executive magistrate's court, then of course there would be no idea of convicting people, but then the executive magistrate would be acting on the apprehension that a particular person would breach the peace, tranquility, etc. And based on that apprehension, that he would be asking the person to furnish bonds under section 126. So, the idea in both places is preventive, not punitive. It has also been observed that breach of peace should be imminent. Now, merely because a case has been registered against somebody, the authorities, so here section 126 may be pressed into action by an executive magistrate. So, it has been observed that if a case has been registered against somebody, that cannot be a ground to ask somebody to furnish a bond under section 126 by executive magistrate, so as to afford the executive some time to get hold of that person, and maybe that they can work out a case against him. That is not the purpose of section 126 BNSS. Now, let us quickly come to section 127. As I said earlier, if you see the title, it is for keeping good behavior. Good behavior is associated with not committing offences which may be punishable with imprisonment. So, for example, theft. Theft is an idea where it may not fall for section 125, section 126, but definitely that it would for section 127 and further. I mean, the person may be asked to furnish bond for security is again bonds, again personal and the sureties. So, here we are contemplating good behavior from persons disseminating certain matters. So, it is a specific idea that only such persons who are disseminating such certain matters that they may be asked by again an executive magistrate. So, judicial courts are absent here. Judicial courts are absent because again it is a preventive idea and nobody is yet being prosecuted. So, we are just preventing people from disseminating certain matters, and this action against them would be except and apart from which that they may be tried for that offence that they would have committed by a judicial court, convicted and sentenced for that. But now this is how that an executive magistrate can prevent somebody to do such things, disseminating certain matters. It says, when an executive magistrate receives information that there is within his local jurisdiction any person who within or without such jurisdiction, that means he might be disseminating that matter within his jurisdiction or maybe outside his jurisdiction, either orally or in writing or in any other manner that relates to section 152, section 196, 7, 299. Now, if you look at them, section 152 is related to acts endangering sovereignty, integrity and unity of India. Section 196 relates to promoting enmity in different groups on grounds including race, religion, etc. Section 197 relates to imputations prejudicial to national integration. Section 299 relates to deliberate malicious acts intended to outrage religious feelings. And So, these are the offences which are contemplated, and it says any matter the publication of which is punishable under these sections. Then it says any matter concerning a judge acting or purporting to act in discharge of official duty which amounts to criminal intimidation or defamation. Then it says makes, produces, publishes or keep for sale, etc., import, conveys, hire, distributes any obscene matter such as referred to in section 294. Section 294 relates to sale, etc., of obscene books. Now, if somebody is doing anything of this sort, then the magistrate, and again the magistrate is of opinion that there is sufficient ground for proceeding. So, again it cannot be bereft of reasoning that must be there, that should reflect from his order, that the magistrate then may, in the manner hereafter provided, require such person to show cause why he should not be ordered to execute a bond, bail bond, for his good behaviour for such period not exceeding 1 year. Now, let us quickly come to section 128. Again it is security for good behaviour. Now, the idea here is that it should be taken from suspected persons. Now, who are suspected persons? Let us read section 128. It says when an executive magistrate receives information that there is within his local jurisdiction a person taking precautions to conceal his presence, and that there is reason to believe, again the reasons have to be there. Any order bereft of any reasoning would be illegal, and there is reason to believe that he is doing so with a view to commit a cognizable offence. That now, in such case, the magistrate may, in the manner hereinafter provided, require such person to show cause why he should not be ordered to execute bond or bail bond, again for his good behaviour for such period not exceeding 1 year as he thinks fit. Now, let us look at section 129. It again, as I said, talk about good behaviour, security, bond, personal surety. Now, here habitual offenders are contemplated. So, if we see, it says that an executive magistrate, if he receives information that there is within his local jurisdiction, so this is the link that he has, link in terms of territorial jurisdiction, that he can exercise his powers. So, within his local jurisdiction, there is a person who A, by habit. Now, you see, if we have a brief overview of these provisions, they all would be containing this phrase, by habit, habitually, 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 habitually. And then it says, as a residuary clause, it says, or he is so desperate and dangerous as to render his being at large without security hazard to the community. Now, if we see them one by one, this is about robbery, housebreaking, thief, as I was trying to illustrate the case of a theft, forge, receiver of stolen property, harboring thieves, protecting thieves, aiding them in disposal of stolen property, or either committing such offence or attempting such offence or abetting such offence. What offence? That the offence of kidnapping, abduction, extortion, cheating, mischief, or any other offence punishable under chapter 10 of BNS, or under section 178, 179, 80, 81, or habitually commits or attempts to commit or abets the commission of offence involving breach of peace. So, or habitually commits, attempt to commit any offence under one or more of the following act: drugs, cosmetics, foreigners, provident fund miscellaneous, essential commodity, civil rights act, customs act, food safety act, or any other offence punishable under any other law providing for the prevention of hoarding or profiteering or adulteration of food or drugs or of corruption. Now, if these are the offences that we have seen, then, or of course, he is so desperate and dangerous to render his being at large without security threat, then in that case such executive magistrate may require, as in the manner hereinafter provided. We will see that procedure from section 130 to end of this chapter. Require such person to show cause why he should not be ordered to execute bail bond for his good behaviour, not exceeding, here it is 3 years. So, we have seen that in section 125, on conviction, a judicial court may ask somebody to furnish a bond to keep peace. Section 126, wherein that the court may, the executive courts may ask somebody, if it feels, if there are reasons that he may show violence in the society, cause breach of peace, etc., then again he may be asked to furnish a bond for keeping peace in the society. 127 for good behaviour, bond for good behaviour. 120 from certain persons disseminating certain material. 128 again for good behaviour from persons who are suspected that they would commit some crime and that they are concealing their presence, good behaviour, good behaviour. And 129 that those who are habitual in such offences, that in the given, some specific given offences, that they would be asked to show good behaviour for a certain period of time. Now, let us look at the procedure, how the judicial court or the executive magistrates court would be requiring people to furnish bonds. If they do not furnish bond, what would happen? How would the court proceed? And such other things. Now, section 130, it starts with section 130 and it says, when a magistrate acting under section 126, 127, 128 or section 129. If you closely look at them, they are for executive magistrate only. So, this procedure has been prescribed for executive magistrate only who would be acting under these sections. Judicial courts, as I said earlier, for them, if somebody is convicted and sentenced for an offence of say writing, etc., as we have discussed, which show violence, and the court is of the view that he would further continue with such activities, then at the time of sentence, the court would be asking the person to furnish the bonds. But if it is an executive court and is acting under section 126, 7, 8, 9, then the procedure given is that if the magistrate is of view that any person may fall under these sections, then it would ask that person to show cause of course, under respective sections. Why? And under such sections, that he shall make an order in writing, of course, setting forth the substance of the information received, the amount of the bond to be executed, and the term for which the bond has to be in force, plus the number of sureties. So, it shows, it contemplates two things. One, that he would be asked to show cause, that is from the suspected side, and that from executive magistrate side, that he would be setting forth the substance of information. So, it would be telling the grounds on which such action has been taken, that he would notify or set forth the amount contemplated for the bonds, the time during which it would be remain in force, and the number of sureties that would be required. Section 131 BNSS says, now these sections 131, 2, 3 and 4 relates to how to procure presence of such person, such suspected person, how to procure presence in the court. Again, I would say that under section 125, the judicial court at the time of sentencing would be requiring the bond. So, the person convicted would be present in the court. But then, if it is a case under section 126, 7, 8, 9, then the accused has to be called in the court, executive magistrate's court. Now, how to call him in the court? Section 131 says that if such person is otherwise present in the court, so for some reasons he is present in the court, it shall be read over to him. It as in the order under section 130, read with, of course, whatever section it is, 126, 7, 8 or 9, that it would be read over to him, or if he so desires, the substance shall be explained to him. If such person is not present in the court, then in that case, it says that the magistrate, again the executive magistrate, shall issue a summons requiring him to appear, or when such person, so if such person is in somebody's custody, so if that person is held by some agency in custody, then a warrant directing the officer in whose custody he is, that to bring him before the court, and that agency then would be bringing him in the court, provided that whenever it appears to such magistrate upon the report of a police officer or upon other information that there is reason to fear the commission of breach of peace, and that such breach of peace cannot be prevented otherwise than by the immediate arrest of such person, the magistrate may at any time issue warrant for his arrest. So, instead of a summon here, a magistrate may straight away issue a warrant of his arrest if the magistrate is of the opinion that the presence of the person suspected cannot be secured otherwise, or that the purpose would be defeated to avoid the breach of peace that he may. Then 133 says that every such summon or warrant issue under section 132 shall be accompanied by a copy of the order made under section 130. So that, of course, as we have seen, that this order, 130 order, would be setting forth the substance of information. So, the person would be getting the substance of information collected against him, and he would also be knowing what action is being contemplated against him and on what grounds, so that he would be able to prepare his defense. And so, such copy shall be delivered to him along with the summon or warrant, as the case may be. Then it says, section 134, that the magistrate, executive magistrate again, if he sees sufficient cause, dispense with the personal attendance of any person called upon to show cause, etc., and may permit him to appear by an advocate. So, that can also be done. Now, let us look at section 135. Now, it says that where an order under section 130 has been read or explained, etc., then and the person suspected appears before the magistrate then shall proceed to inquire into the truth of information upon which the action has been taken. That means, the earlier order passed under section 130 was a prima facie order, that the magistrate was of a prima facie view that such situations exist and that such person must be called in the court. So, he shall inquire about the truth of the information, and for that purpose he would be taking further evidence. Further evidence again shows that he had some evidence earlier, some evidence, and that he formed a prima facie view based on that some evidence. So, further evidence for getting to the bottom of the matter may also be taken. Then it says, such inquiry may be as far as possible, as nearly as may be practicable, should be as we do in summons cases. So, further evidence would be recorded as we do in summons cases. After the commencement and before the completion. Now, clause 3 says, now it contemplates an interim bond. It says that if after the commencement and before the completion, the magistrate is of the view that immediate measures are necessary. So, immediate measures we have already seen here, that warrant may be issued against somebody to procure his presence, and here also that when he is produced before the court, if there is urgency in the matter or the purpose would otherwise be defeated, then the magistrate may ask him to furnish interim bonds in the court until the matter is pending in the court. And he may be kept in custody till he furnishes such bonds, or if he defaults in furnishing such bonds, he may be kept in custody during the entire pendency of such inquiry. Then it says, provided that no person against whom proceedings are not being taken under section 127, 28, 29 shall be directed to execute a bond or bail bond for maintaining good behavior, and that the conditions of such bond, whether as to amount of the personal bond or as to the surety or the number of them, shall not be more onerous than those specified in the order under section 130. We have already seen, if you remember, that under section 130, we have contemplated that he would do these things, would tell the grounds, tell the amount of bonds for the time that the bond would be there, and the number of sureties. So, whatever has been told here, when the court asks him to furnish an interim bond here, then such interim bond would not be more onerous than those conditions which have been communicated to him under section 130. Also, as I said, A that such interim bond may be directed only in section 127, section 128 or section 129. That means such bond cannot be, such interim bond cannot be asked if the proceedings are under section 126. In that case, no interim bond can be required. Now, let us look at the further provisions here. It says that when there are two or more persons who are associated together in the matter under inquiry, then they may be dealt with in the same or separate inquiries as the magistrate shall thinks fit. So, you see, two or more persons may also be held in one inquiries and they would all be asked to furnish bonds. The inquiry under this section, then it says that the inquiry under this section, but of course, such two or more persons must not be from two warring groups. So, if there are two warring groups, group 1, group 2, then they must be inquired in different inquiries, as in they should not be clubbed together. But if they are on the same group of persons, in that case they may be held at the same inquiry, as I stated. It further says, the inquiry under this section shall be completed in a period of 6 months, and if such inquiry not so completed, shall on the expiry of that said period stand terminated, unless for special reasons that it may be extended, unless terminated earlier shall stand terminated on the expiry of a period of 6 months. So, executive magistrate must complete the inquiry within 6 months. So, inquiry contemplated under section 135 must be completed within a period of 6 months. Of course, if the magistrate, for special reasons to be recorded in writing, if the magistrate otherwise direct. Then clause 7 says, where any direction is made under section under subsection 6 permitting the continuance of proceedings, the session judge may, on an application made to him by the aggrieved party, vacate such direction if he is satisfied that there was no special reason or that the reason was perverse. So, as we have seen, ordinarily this proceeding would terminate at 6 months unless the magistrate records reason, and that reason then would be scrutinized by session judge. It also says that if the person has been kept in detention pending such inquiry, then the proceeding against that person shall terminate on the expiry of said period of 6 months. And in that case, so here there is no extension, there is no extension possible here. So, if the person has not been kept in custody during pending inquiry, so if it is an ordinary case, 6 months unless recorded reason, scrutinized by session judge. If suspected has been during that time period has been kept in detention, then there would not be possible any such extension by executive magistrate. Coming to section 136, it says final order after inquiry. Now, it says if upon such inquiry. So, whatever we are discussing till now was pending inquiry. As to pending inquiry, that you would ask him to furnish interim bail, that interim bond, or that we may keep him under detention pending inquiry in other case, or that. So, now section 136 says that upon such inquiry, if it is proved that it is necessary for keeping the peace or good behavior, that the person should execute a bond, he shall make an order accordingly, provided that, of course, no person shall be the conditions of those bonds shall not be more onerous than those communicated to him under section 130 earlier, and the amount shall not be excessive, and if the person is a child against whom the inquiry is made, the bond shall be executed only by his sureties. Section 137 says that if on inquiry under section 135, it is not proved that such bond is necessary, then the magistrate shall make an entry on the record to that effect and shall release such person if he is in custody, or if such person not in custody, shall discharge him, release him or discharge him. Discharge him as in close the case and discharge him. So, we have seen section 135 that permits pending inquiry to ask somebody to furnish interim bond, pending inquiry even to detain him, as it says, and may detain him in custody until such bond or bail bond is executed, or in default of execution of them until the inquiry is concluded. So, the person may also be detained if he does not furnish these bonds, interim bonds, and then the inquiry would be conducted and then final orders would be made. The inquiry may be conducted for 6 months. Ordinarily, if he is outside 6 months, but then it may be extended, scrutinized by court of session, but in no case that it shall be extended beyond 6 months if he is under detention. Now, commencement of period for which security is required. Now, it says section 138 says that such person under whom this bond is required under section 125 again judicial court, or section 136 as in executive magistrate court, the time such order may sentenced to or undergoing a sentence of imprisonment, if he is already imprisonment or he is being sentenced to imprisonment. So, this relates to this case only. If he is in jail or if he is being sentenced to jail, in that case, then the period for which such security is required shall commence on the expiration of such sentence. So, such bond would commence as in the time contemplated in that bond to keep peace or to show good behavior would start when he would come out of the jail. 1 year after he comes out of the jail, 2 years after he comes out of the jail, etc. Then it says, in other cases, such period shall commence on the date of such order. In other cases, other cases as in where is outside imprisonment, outside prisons. So, in those cases, such period shall commence on the date of such order unless the magistrate for sufficient reason fixes a later date. This date may be fixed for various reasons. Say for example, giving time to the suspected person to arrange sureties, or maybe that something happens that change the circumstances and the court requires as in feels that it may not be executed at that point of time when the order is pronounced. Maybe it will start from a later date, that the bond would be required to be furnished from a later date. So, in that case the court may fix a later date. Section 139 again it says that bond to be executed by any such person shall bind him to keep peace or good behavior, and in later case, this we have already discussed, that in later case, later as in good behavior case, he would not commit any offence, attempt or abet any offence which is punishable with imprisonment, and wherever it is committed, wherever as in irrespective of territorial jurisdiction of the court, irrespective of that. So, if the court is situated in Delhi, he cannot show bad behavior in Mumbai also, So, That was the idea associated with these bonds. Thank you.
Hello, good morning everybody. I am Raghunandan Sengupta. So, I will just give you very brief excitement area of finance, which is quantitative finance, and that has a huge market starting around about 10 years back, and it is exploding exponentially. So, what do we mean by quantitative finance? Quantitative finance is actually the application of different mathematical and statistical techniques in the area of financial markets, be it say for example derivative pricing, be it in the area of say for example portfolio management, be it in the area of asset liability management, be it in the area of portfolio management. We see that the application has exploded in such a way that there is a huge opportunity for people who have a quantitative background in mathematics and statistics. They can utilize those in the area of finance, but obviously with some prior knowledge of finance as a subject. Now, when we say about quantitative finance, as I said, it is an area of applied mathematics and statistics applied in financial markets. Use of different areas, if somebody is interested to know, we have stochastic calculus, we have derivative pricing, we have operation research, we have quantitative techniques like differential equations, stochastic calculus, time series, and they are heavily used in the area of quantitative finance as I mentioned. Now, we all know that in 1997 the Nobel Prize in Economics, so it is basically the Nobel Memorial Prize in Economics was given to the work of Merton and Scholz in the area of derivative pricing, and after that there has been exponential increase in the area of quantitative techniques in quantitative finance and in the area of different type of derivative pricing. With the advent, moreover with the advent of high-ended and sophisticated computing data, big data has come in a very big way, where application areas starting from computing, from different type of algorithm design have been taken up in such a big way that nowadays at least we are able to understand that how high frequency data algorithm trading can be utilized using the concept of quantitative finance in the area of finance as such. But there is a flip side also, obviously when there is a huge amount of development. So, obviously due to some regulation errors or something, there has been some pitfalls, which I think is should be a bullet point for people who are really interested to take up quantitative finance, they should be aware. So, consider the financial crisis in 2008 and later on, and we are seeing different banks are failing, different financial institutions are facing a problem, countries are facing a problem like in Europe, in USA. So, what should be done? So, the main thing is that even if you know the technique is best for people who are investors, who are private players, organizations like banks, governments should use these techniques in a very somber manner, such that the application areas of quantitative finance using the techniques which we learned can be utilized in the best possible way to garner the overall the in-depth knowledge a person has in trying to utilize these quantitative techniques in finance. And I am sure that people who have the background, who have the knowledge, who have the sophistication, who have the knowledge of the society can definitely use quantitative finance in a very big way in trying to make their mark in this exciting field, which you are going to see in years to come. And I am sure it will be a very exciting learning tool for all the participants who will take quantitative finance as a subject in years to come. Thank you, and I wish all the participants all the best and best of luck for the programs they will take. Thank you.